May I please, Lord? I beg to mention item 14, Lord.
Item
14, 1-4.
1-4.
Yes. I may be allowed to withdraw the petition.
Okay. Mr.
S.H. Ram.
S.H. Rahman, learned counsel for the petition, has submitted that he has received instruction from the petitioner not to place this petition. Any Miss
Yes.
M. Bormon, learned junior government advocate for the state respondents, and anybody from Mr. J. M. Chaudhary?
Yeah. Are you preparing for that?
Okay, he's present. And view of the above.
Appearing for SK Talukdar,
Miss-
Cooperation
Miss-
Department. L Khati.
L.
Khati.
Khati,
KHATI.
Khati. Okay,
Come.
on behalf of Mr. S.K. Talder and standing
Mr.
Restoration Department are present in view of the above submission made by Mr. Rahman, learned counsel for the petitioner. The petition is dismissed as unusual.
She is appearing for respondent number.
Miss,
My learned counsel, J.M. Chaudhary,
your name please?
M. Paul.
M. Paul, huh? As per J.M. Chaudhary. As per number 6.
Obliged, sir. May I please, your lordship? I beg to mention item number 12, lordship. With consent of other side, lordship, they have filed affidavit. You need to type to file a reply, lordship.
Who has filed affidavit?
Respondent number 5, Lord. I am appearing.
Okay. Mr. R.L. Chutia,
Lordship.
learned counsel for the petitioner. And Mr. D. Dole, learned counsel for Ms. M. Bormon, learned junior government advocate for the state respondents, and Mr. D. Dole
No, Lord, private.
for the respondent number 5 are present. Post of Mr. Here, learned counsel for the petition is paid for and is granted. How much time you need?
3 weeks. 3 weeks. 3 weeks.
3 weeks to file an affidavit in reply to the affidavit of opposition filed by the respondent number 5. This is the case after 3 weeks and it will be by the office. Any interim order?
Interim, no.
File over.
Obliged.
Permission, would like to mention item for listing, lordship, motion. Lordship, let it be come on Monday. I have filed it.
What is the subject?
Lordship, register cooperative societies. Order needs.
May I please, your lordship? Lordship, I beg to mention for listing of a petition on Friday, lordship.
What is the motion?
No, lordship, orders.
Give to the court master.
May it please, my lord. My lord, with the consent of the other side, I beg to mention item number 4 and 5 of the daily list, my lord. An adjournment slip was circulated yesterday, my lord.
Okay. Who is for the petitioner?
No, she's appearing.
Miss? Name, your name please. Give up. For the petitioner is present, Mr. H. Borua. Learned counsel on behalf of Mr.
B. Gogoi, my lord.
B. Gogoi. Learned additional advocate general for the state respondents. You are seeking time?
Seeking time, my lord. Otherwise, pleadings are complete in this matter, my lord.
Okay. Listing of the matter after what time?
After a week, my lord. Any day, my lord.
After 2 weeks. That's what listing of the cases after 2 weeks. With the consent of the procedure as the prayer is made. With the consent of the learned counsel for the petition and the mentioned memo to that effect has already been circulated yesterday. The prayer is allowed. List the cases after human question.
2
2
weeks.
weeks.
Thank you, bless, my lord.
May I please, your lordship, lordship, I beg to mention for listing, for admission, lordship.
Admission.
Yes.
Give it to the court master.
Wait, please, your lordship. Lordship, I beg to mention item number 15. Lordship, in this matter, learned senior counsel A. Saraf was were to appear today, but due to some personal inconvenience, he is unable to appear. Therefore, your lordship may kindly take this matter up after 2 weeks.
Oh, just a minute.
15 to Sabita.
Item number
15. Your lordship.
15. The prayer is made by Mr.
P.
You-
Jalan.
P. Jalan, learned counsel. On behalf of Dr. A. Saraf, learned senior counsel for the petition. For adjournment of case with the consent of the learned counsel for the respondents. As paid for, is the case after. What time? 2 weeks on a date to fix by the office.
Much obliged, your lordship.
Please, your lordship, I beg to mention item number 8. I'm appearing on behalf of D. Ghosh. She is out of station actually.
Your name, please,
So as Fukan,
as spoken, learned counsel. On behalf of Mr. D, Ms. D. Ghosh, learned counsel for petition has made a prayer for adjournment on the ground that Ms. Ghosh is out of station due to personal area. So as the prayer is made with the consent of the learned counsel for the respondents, the prayer is allowed. Leave the case as sought for after
any date.
after 2 weeks.
Actually, the petitioner is a victim of acid attack.
On so and so.
1st June, 1/6.
I don't know.
May I please, your lord, so my lord, I beg to mention for listing of two motion items tomorrow, my lord, for eviction items, eviction matters. Okay. Miles. Oblige, my lord.
Lordship, I just mentioned item number 15. There was an interim, your lordship.
Okay, the interim order passed.
Interim may
15.
15. Much obliged, your lordship.
Supplementary list for withdrawal, item number 17.
May I please?
Yes.
Matter become infectious.
Okay, Mr. You got the relief or what?
Yes, Lordship, relief has been granted.
Mr. I can learn for the petitioner has submitted that since during the pendency of the petition, the petitioner has got the relief sought for in the petition. The petition has become infectious. Ms. M. Borman and Junior Government Advocate. So
Okay.
for the respondent number 1, 3, and 4 is period. In view of the submission made by Mr. Akan, learned counsel for the petition, the petition is dismissed as infectious.
So, Lord.
Daily list for motion, item number 1.
Lordship, I beg some liberty because there is some typing mistake so far respondent number 10 is concerned. In the, I mean, written statement, I put it respondent number 9, actually respondent it should be 10. So it may kindly be given the liberty, so can correct it and again next day.
What correction?
Respondent number 10 should be, in the written statement, I put it as respondent number 9, this will be respondent 10.
Paragraph number 2.
Paragraph, page number 10, paragraph
Page number
10, block letter, the ground for initiate listing, that should be respondent number 10. I, in place of respondent, I put respondent 9 by typing mistake.
Okay, that is one mistake. Any other place?
No, because his respond several times his name came into picture. Give me some liberty, I will correct it, give some. It is serious matter.
What is the case about?
Yes, if the lordship, this is basically an inquiry conducted by the irrigation
Will
department.
not be initiated against it. In the prayer portion also.
Yes. So. Yes. It's a very serious matter.
But have you lost any FIR?
No, actually, I filed a complaint to the government.
No, government will not do. If you are seeking an investigation under provisions of BNSS.
But the government only made.
What BNSS? Bharatiya Nagarik Suraksha Sanhita. Right. What is section 59?
59 and.
ENSS to the CRBC, right? No? Oh.
Inquiry conducted by the government already.
Mr. Bhattacharya, your prayer is wholly misconceived. Firstly, BNSS is procedural law. It does not speak about any offense.
But so far other is concerned 316 and 31.
No, I have seen each of the three, 59, 61, 3165, right? So this writ petition is wholly misconceived. Firstly, you have to, if you find that there is commission of a cognizable offense, then you have to lodge an FIR. If the FIR is not registered, recourse is available under BNSS to follow the matter before appropriate authorities and thereafter before the court of law. But here, criminal proceeding will not be initiated against respondent number 9 or 10 under section 59, 61, 3165 of BNSS for his active involvement in the relevant crime. We do not direct registration of FIR. You have to file the FIR.
Lordship,
Thereafter, if the FIR is not registered, then there are recourses available to you.
Lordship,
Irrespective of typographical error regarding respondent number 9 or respondent number 10, if you make the correction, it will not change the character of the
petition.
case and petition, which is after correction also
Remains same.
will remain same.
But Lordship, this government has made an
That is
inquiry.
different matter, but your prayer, we consider first your prayer. This prayer is not tenable. You have to structure your petition in a different manner, not in this manner. If you have any grievance, first you lodge the FIR. If there is something has been revealed in any report regarding misconduct of respondent number 10, file an FIR, seeking an investigation. If that FIR is not registered, follow it up to the SP or DGP. Thereafter, approach the court of magistrate. I don't think this is with correction. Anything is going to happen. This is misconceived. It is not structured in the proper manner. Mr. Bhattacharya, I can give liberty, but giving liberty is of no use.
At least
Yes, Mr.
Lordship has correctly said, Lordship. In fact, Lordship, the petitioner has been cautioned by the coordinate bench of the court for filing similar petitions,
no,
Lordship.
this is reparting.
Lordship, in that petition also, Lordship, he prays for initiating criminal proceeding, Lordship. The court strictly, Lordship, said.
No, Lordship, this is department. This is inquiry conducted by the irrigation department. Inquiry is conducted. Inquiry is very much.
Lordship, Lordship has correctly
You
said, Lordship,
don't-
if
don't-
he has any
don't mix-
grievance, Lordship, he can go to the police first, Lordship. Then he can go to the magistrate also, Lordship, under section 156(3).
Don't mix two cases together.
No, I am anyway, basing on the prayer, I am closing this.
Lordship, oblige, Lordship.
But inquiry report is very much against him. There is inquiry report which is conducted by the 3-member committee.
No,
It is-
that will not
No, what
wipe out.
You-
Dismissal of the writ petition will not wipe out the inquiry report. But
That's the-
question is the relief sought for and the manner in which the relief sought for. I don't think this is maintainable. We do not direct registration of FIR.
Yes. Inquiry is very much against him.
Who will initiate criminal proceeding? Police?
Yes.
Nobody else. So for condition precedent for initiation of criminal proceeding is an FIR. Not a writ petition first, then an FIR.
Yes, right. Yes.
Third, Mr. heard the petition in person. And Mr.
Lordship, I am for 2-5
N. Upadhyay, Learned Standing Counsel,
irrigation,
Irrigation Department for the respondent number. Yes, please tell.
256789.
And Mr. H. Sharma, Learned Additional Senior Government Advocate, Assam for the respondent number.
State is not a
Okay,
party.
first
but
part.
1 and 3.
No,
One and-
Secretary Party.
Chief Secretary State was.
Oh, yeah, yes, yes. Yes.
The petitioner in person
Nine.
has instituted the instant petition seeking to invoke the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India, seeking a direction to initiate criminal proceeding against the respondent number 10, who has been impleaded inadvertently as respondent number 9, under section in the petition in person has sought initiation of criminal proceeding against the respondent number 10 under section 59, section 61 and section 316 within bracket 5 of Bharatiya Nagorik Suraksha Sanhita 2013 for alleging the involvement of the respondent number 10 in committing crimes in the capacity of executive engineer, Morigaon-Lahorighat-Jagirot Division. It is mentioned that the respondent number 10 is presently posted as the director, planning, post-roco, the additional chief engineer, planning and research, Sanmari, Gauhati. Before any derivation, it is relevant to mention, refer to the provisions of section 59, section 61 and section 3165 of the BNSS poster. Section 59 BNSS has provided that the officer in charge of a police station shall report to the district magistrate and so and so. Poster. Section 61 BNSS has provided for power, on escape, to pursue and retake. If a person in lawful custody escapes or is rescued, the person from whose custody he escaped or was rescued may immediately pursue and arrest him in any place in India. And the provisions of section 44 BNSS shall apply to such arrest, although the person making any such arrest is not acting under a warrant or is not a police officer having authority to arrest. Subsection 5 of section 316 BNSS has is with regard to record of examination of an accused. Para. From the statements and averments made in the petition, it transfers. It is noticed that allegations are made against the respondent number 10 with regard to irregularities he had allegedly committed during his tenure as executive engineer Morigaon, there's Lahori Gap, there's Zagiro division within irrigation department in various tender processes. So the petitioner has alleged that while discharging his duties as a public servant, the respondent 10 had acted in violation of the delegation of violation of the power delegated to him on financial aspects, and to support his case, the petitioner has relied upon a report submitted by the additional chief engineer, inspection, Roman quality control, irrigation department, Assam. Postal. There is no averment to the fact that the petitioner has lodged any complaint before the police alleging alleging commission of any offense by the respondent number 10. এই কালিয়াটা যে দিছিল এইটো কালিয়াটা যে পঠাই দিল কালিয়াটা যে রিফার করছিল রিসেন্ট পুরোহিত সুপ্রিম কোর্টে দিছে হ্যাঁ প্যারা the prayer the relief sought for in the petition is initiation of criminal proceeding, is a direction for initiation to the respondent authorities to initiate criminal proceeding against the respondent number 10 under the provisions of stated provisions of BNSS. Full stop. without, without any approach by the petitioner to invoke seeking statutory remedies provided under the BNSS. Full stop. Without availing such statutory remedies provided under the BNSS, the petitioner has approached this court by the instant, has directly invoked the writ jurisdiction of this court, seeking direction for initiation of criminal proceeding. Full stop. In the considered view of this court, such a recourse, in the first instance, is contrary to the settled principles of law. Full stop. Entering such a petition in the above facts and circumstances would amount to a situation that would so para in Sujal Bishwas Attavar and another versus the state of Maharashtra and others, 2026 INSC 442, decided on 4/5/2026, it is observed that the High Court is not bound to entertain a writ petition merely because a case of alleged inaction or negligence is made out against a statutory authority, first of all, ordinarily, where a statute provides a complete and efficacious remedy, the same must be exhausted before invoking constitutional jurisdiction, as has been held in Sakiri Basu, Sakiri Basu, pura naam to give and Sudhir Bhaskar Rao Tambe. First of all, in view of the approach made by the petitioner in person through this writ petition is found to be a misconceived one, and therefore the writ petition is dismissed.
Not your obliged.
Supplementary list, item number 18.
May it please your lordship.
Yes.
Lordship, I have gone through section 112 and 113 of the GST Act. Although there is a alternative remedy available to the petitioner, but if lordship would permit, I would make a short summation on the point of maintainability and why the order passed by the first appellate authority is arbitrary.
Maintainability is not a question.
Yes, your lordship.
It is the entertainability
Absolutely.
which is in question.
So, lordship, in that matter, the petition would be entertainable because the order passed by the first appellate authority is arbitrary, and as such, it would fall in the ambit of the four principles laid down in the judgment of Honorable Apex Court in Whirlpool. If lordship would permit, I'll just make a summation of the point of arbitrary.
Let us see your facts first. Then we'll reach the appellate order.
Yes, sir.
PST.
Lordship, may I read?
What is the initiation?
Lordship,
Point.
initiation is regarding input tax credit, ITC. So the grievance is
This
that,
ASMT 10
yes,
is issued under which provision?
Lordship, pardon.
ASMT 10, Annexer 1, is
Oh,
issued under
it
which
is
provision?
issued under Lordship, see.
70.
71 is the
70 or
71 is the
71?
show cause notice, Lordship.
SMT. এই ফৰ্ম থকাখন ক'ত আছে? ফৰ্ম থকাখন ইখন এখন যে আছিল ফৰ্ম থকাখন। GST.
73 1 year, Lordship. 73 subclause 1, Lordship.
73 subsection 1 is show cause notice.
Yes, sir. Lordship, the first
ASMT is. Yes, Mr. Kyle,
Lordship, page
ASMT
16.
10,
Lordship, page 16.
page,
16.
no, section.
Huh? under section 61, Lord.
61.
Rule 99, Lord.
Rule 90.
9.
Rule 99.
Rule 99.
Just a minute. I have to refresh myself.
Motivation दे दी।
So this was issued under Rule 99. Let us see what is the content. Over to Bhumi.
Page 16, Lord.
Page 16, proposed intimation.
39. Pencil 9. Did you respond?
Yes, Your Lordship. After this was intimated to us,
Did you respond to this notice?
we respond to the replies, to the show cause notice that was
No.
sent.
First, under 99,
Yes, sir.
when a notice is served under ASMT 10,
Yes, sir.
you have to respond by ASMT 11,
Yes,
Correct, your lordship.
right? Then order will be passed under ASMT 12,
12, yes, your lordship.
right?
Yes,
So it is your case, you have received this notice,
yes, sir.
but you did not respond.
Respond.
Then proper officer had no other option.
So cause notice was issued.
Then so cause notice was issued.
Lordship, on
Where
the,
is the so cause notice?
it is
Page
in
20.
page 20, your lordship.
Page 20. Because if you do not respond,
Yes,
it
sir.
is presumed to be correct under sub rule 3 of Rule 99.
Not.
Lordship,
Right.
that fact is not disputed here, and I'm not.
Let us see
Yes, sir.
the sequence of events.
Yes, your lordship.
You cannot pick up something from somewhere and argue your case.
No.
Because here it is not you are remediless,
Yes, sir.
right?
Correct.
So that is why we are examining the case.
Yes, sir.
Had it been remediless, it would have been different matter.
I understand. Your lordship.
There is a question of not maintainability, entertainability.
Yes, sir.
Okay, then page 20.
Page 20 is the show cause notice.
Same, section 39, section 16.
Yes,
So same figure.
same. Your lordship.
Discriminates in the form of issued to the, it is mentioned. You did not submit
Submit
any
any
reply.
yes, sir.
So, natural consequence is issuance of a so cause notice. Excess ITC, interest, penalty. Did you respond to this?
Yes, your lordship. In page 24, your lordship.
Page 24.
Lordship, herein,
Then where is the order in original?
order is on original.
Page 33.
33. Your lordship.
Yes, then
Then, Lordship, after this order was passed, I preferred an application on for rectification before the same competent authority. That was on 8/3/2025. The order in original was passed on 3/1/2025. After which I preferred an application for rectification on 8/3/2025.
what is the provision for rectification?
The provision for rectification is, Lordship, 161, Lordship.
161.
Yes.
Section 161.
Section 161, Lordship.
Yes. Then what happened?
Then the rectification order was decided and an order was passed on 24/4/2025, where my contention was rejected. Thereafter, your lordship, on 23/5/2025, I preferred an appeal in front of the first appellate authority.
24 page.
Lordship, the page of order in order rectification order is at page, lordship, 45. Page
45. Then order was appealed.
Appeal application is at page 46, next page.
Which date?
The date of appeal, I prefer the appeal on lordship 23/5/2025.
23/5/2025. 3/5/2025.
Yes, your lordship. And lordship would find the order of appeal in page number 72.
19/2/2026.
Yes, the
Okay.
order of appeal was passed.
Now, tell me what are the infractions? At which stage infraction, according to you, has been committed?
Lordship, my submission would be that.
Which stage? Original stage or appellate stage?
The appellate stage, the appellate
Appellate.
authority had to consider.
What kind of infraction?
Because Lordship, the order in original attained finality after the rectification order was passed by the same competent authority. So the computation of limitation should have been from the date when the rectification order was passed rather than the date when the order in original was passed. So the appellate authority, while passing the order, they computed the date from 3/1/2025. Or if Lordship would come to page. Lordship would come to page 80. In paragraph. And Lordship, in section 107, subsection 1, there is no mention as to whether the appellate authority, the order should be in order in original or the rectification order. The date should be commenced from order in original or from the rectification order. So hence, the order in original attained finality after the order in rectification was passed.
When was the order in original?
Order in original was passed on 3/1/2025, Your Lordship. The same day that the application was. That your Lordship would
Page.
claim.
T1 2025.
25. It's in page 33, Your Lordship.
T1 2025. Then your rectification application was.
The application for rectification, we filed it on 8/3/2025. And the order was passed on 24/4/25.
24/4/2025. T1 2025. T1 2025. Order in original. Rectification order was passed on 24/4/2025.
2025, Your Lordship.
And what is the date of appeal?
We filed our appeal on 23/5/2025, Your Lordship.
With pre-deposit?
Yes, with deposit, Your Lordship.
With pre-deposit?
Pre-deposit. Lordship, as of date, there is no pending dues of the petitioner regarding.
T1. Now, what are the reasoning given by the appellate authority?
It's at page 80 of it. Discussion and findings. Paragraph 9. Also in paragraph 10, they have mentioned the date from which the limitation was computed.
Mr. Kyle, what is the corresponding rule in relation to 161, 147, 142.7?
Yes, sir, 142. Lordship, it would be 142 Rule 7.
Right, I have seen.
Page 260.
Where is your rectification application?
Rectification application is a page, Lordship. It's a page 37, Your Lordship. Page 37. Annex 7.
Yes, Mr. Kyle,
Lordship.
rectification somewhat akin to review.
Lordship, what happened? Lordship, may please to see the appeal filed by the petitioner. Although he has mentioned about the dismissal of his appeal, Lordship, may please to see. He has page 46.
Hmm.
Page 46, column 5.
Hmm.
Order in original dated 3/1/25.
No mention of that.
No mention of rectification order has been made before the authority, appellate authority.
Where is your memo of appeal?
Lordship, page, although in some paragraph he has stated about
Lordship, we have been.
Have you mentioned about,
Yes,
page
Your Lordship.
50, page 50.
have you mentioned about rectification?
Yes, Your Lordship.
Statement has been made, but Lordship been challenged, or challenge is made to order dated 3/1/25 only.
Obviously,
Lordship.
that is the main order.
Yes.
See, normally what happens? Order in original, read petition. Say, for example, this is constitutional principle.
Yes, Lord.
Order in, by the original order by the, in the read petition.
Lord,
A review is filed. Review is dismissed.
we are challenging both
That
orders.
that order, no, you do not have to change, you have to mention it,
Yes, Lord.
but the original order is to be challenged,
So limitation will count from the date of
right? From the original order.
Late order.
Original order,
Lordship.
from the original order,
Lordship.
but in between this review application was pending. So Constitutional Court,
Yes, Lord.
Constitutional Court takes into account the fact of pendency of the petition. Thereafter, at the appellate stage, it
Review has been filed. Review or what?
that delay is ordinarily condoned.
Yes, that for abundant question, we have to file an application for condonation of delay. That is.
But as an abandon, that is found to be sufficient cause.
Yes, Lord. Yes, Lord. That is correct.
Right, under section 5 of the limitation.
Lordship.
Here is a question that appeal is required to be filed within 90 days plus
3 months.
30 days.
plus 30 days.
No, Lordship, 107, 30 days.
But
3
subsection,
months plus 30 days, Your Lordship.
subsection,
They have to file application for condonation of delay.
that-
It is a file after 30 days, Lord.
right,
But that is missing in this case.
107.
Lordship.
107,
One lot.
subsection 4.
Subsection 4, the appellate authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period 3 months or 6 months, as the case may be, allowed to be represented within a period such a period of 1 month.
That has been noted by the appellate court.
Yes, no, no, no.
Appellate forum, that fact has been noted
Yes, sir.
in page 81. But the fact that whether in the statutory scheme of things, when a power under 161 is available
Not so,
and that amounts to an order,
not so.
right, then if affected person has been given the right to file a rectification application.
Yes, Lord, sir.
Right.
It is
And that can be decided either in favor or against.
against the petition.
So the original order, this rectification order would merge with the original order.
Yes, correct.
Right. If it is allowed, then it will be a subsequent order. This provision is available in between. Then from which order the period of limitation would be counted? This is also right.
Lordship, correct. Lordship is correct. But here, Lordship, in appeal, they have, although they have mentioned, but in page 46, Lordship, only they have challenged the order.
Lordship,
The appellate authorities. Page 46.
Page 51.
Lordship, in that regards,
Page 51.
Page 51. Lordship.
First line.
Yes, Lordship, it is correct. They have mentioned about this, but Lordship,
A challenge also, they said,
no, Lordship, may please.
issued by the so-and-so some ground, rejecting the rectification application without affording any personal hearing and failing to alter the original demand.
Lordship, may please too. I'm whatever Lordship has stated, I have understand, Lordship. But here, the challenge was made to order original order. Lordship, may please to
This
see
is the
page 50.
form.
Page 50.
This is a statutory form.
No, no, Lordship, page 46 is statutory form. Page 50 is the statement given by the petitioner. Lord.
Huh? Page
Order-
51 here said order appeal
order-
against, order
appeal against.
appeal against, then rectification application and rectification order challenged. It is not that he has not mentioned it.
No, no, Lordship, I've stated that they have mentioned, but
But the question I am asking, the question of law I am asking is that whether the period of limitation, since a right has been provided
Yes,
to
yes.
an affected person in the act itself
correct, Lord.
to file an rectification application.
Yes, that is there.
Right.
Yes.
So in the constitutional scheme, there is nothing. It is court of record 215 actually.
Yes, Lord.
But
No, no.
where, say, CPC,
Yes, Lord.
review application is filed, review application is dismissed, then period of limitation is to be counted from when?
Lordship, from the date of rectification review order, but we have to file an
What is
application.
the exact provision?
The exact
CPC.
provision, exact
You
provision.
are also convergent with CPC.
No, Lordship, yes. Lordship, here we have to, limitation will count from the original order. However, petitioner will get benefit of review order passed, the subsequent date from which it has been passed. But it is mandatory to file an application for condonation of delay. This will be the reason that we have preferred a
No,
review.
no, I am, that is why I am, see. As that arbitration case,
Yes.
3 months plus 30 days, thereafter,
No,
nothing.
yes, but here it is not.
No, it is there, subsection
Four.
4. 90 days
Plus 6.
plus 30 days. Nothing
Yes.
thereafter. Right. Everything is closed. No appeal. Right. It will be barred by limitation. But you have provided a right under section 161
Yes.
CGST Act to file a rectification application. Maybe baseless.
Whatever.
The
it is.
ground.
Yes, Lord.
But you have provided a right.
Yes, Lord.
Right.
Correct. Lord.
Which is akin to review.
Yes, Lord.
Right. Now tell me, by referring to the provision of CPC, there 114, section 114, read with order 47, rule 1. review is permissible,
Permissible.
right? After order in review, in CPC, not 226.
Yeah.
Don't go to writ petition
That's
and
it.
writ appeal. In CPC, how the period of limitation is to be counted?
Let's say from the date of original decree.
Which provision? Limitation Act.
See, limitation is moving. Let's say, but he will get the benefit of review if then he has to file an application for under section 5 of the Limitation Act, stating the reason he will get benefit of that period.
Is there any precedent, Mr. Bhuya?
Yes, your lordship, lordship would, there's
Any precedent authority?
Lordship, precedent as in like lordship, I have a judgment of the Allahabad High Court where the law has been stated regarding section 14 of the lordship would come to section 14 of Limitation Act. Section 14 is exclusion of time proceedings bona fide in court without jurisdiction.
No, mister, you are wrong.
Yes.
I'm sorry, lordship.
This is Limitation Act is applicable for General Act,
Correct.
not in Special Act. But if there is some power akin to review in the CGST Act, then what is the implication?
Yes.
How the period is to be counted? Section 14 will not come directly.
Yes, sir.
If Section 29, subsection 2 of Limitation Act,
Correct.
read it. Now, yes, Mr.
Lord.
Can you provide a limitation act? I am asking this question to Mr. Kyle because he is also conversant with CPC.
Lordship.
Let us see period of limitation. Court appeal, second division. Second division. Mr. Bhuya, Limitation Act will not come in CGST where specific period of limitation is provided, right? But we are into the concept because 161 provides for a revocation application. That creates a new right.
Yes.
Because if revocation application is allowed, yes,
He's got the relief.
no grievance then thereafter. But if revocation application is dismissed, on the other hand, there is a specific period of limitation.
Yes, Lord.
90 plus maximum 30, 120. So from when the period of limitation would
Let's see, in
be counted?
my submission, let's say from the date of original order, you will get the benefit of the period when the rectification.
Question is here, power of the appellate court to condone limitation is only for 30 days.
Yes.
Beyond
6.
90 days, right?
Yes.
And it has been settled like that arbitration case, which one I forgot the name. arbitration case, 3 months plus
30 days.
30 days. That consent is applicable.
That is approved.
Thereafter, nothing.
Nothing.
So here, thereafter, nothing. But question is in between this, revocation provision has been made.
Definitely, he will get the benefit of that period if he has filed an application stating all the reason before the authority.
No, here is a case.
Not
You
si-
come from the original order. Making an application or not making an application will not make any change because it is beyond 90 plus 30, 120 days. That will not change.
Yes, correct. Sir.
Right. Making an application will not make a difference. Then also appellate court has to dismiss it. If you go by this
Yes.
reasoning.
Correct. Lord.
Right. No point.
But in
But
my
question is, if he is under the belief that period of limitation is to be counted from the order passed in revocation application, and if his thing is correct, then it will be within time.
Lordship, in my humble submission, probably he will get the benefit of the rectification, the order of
That is, please, that is why I am said,
Lordship.
if that is, then that is a question of law. Nothing on facts, simple, undisputed facts.
No, that is Lordship, probably in my humble submission, probably.
No, because in the absence of authority, I should not.
Then Lordship may fix some other day, I'll come with an authority because some.
Sir,
there is
Bhuya,
some-
have you
I
understood?
understood your lordship.
Lordship,
But limitation will not come in. But
Very good.
question is whether after revocation of application an order is, because a right has been provided to an affected person to file a revocation application.
rectification.
Whether it is has merit or no merit, that is a different issue.
That is the difference.
But if revocation application is allowed,
Very good, lordship.
then the affected person will not have any further grievance.
Lordship, correct.
Matter would rest there.
Yes.
But if revocation application is dismissed, then he has
Appeal.
cause of grievance.
Correct.
He has to apply for the permitted remedy of appeal,
Yes.
statutory remedy.
Lordship.
Then by that time, if the period expires,
Very good.
Lordship.
you have provided, because here you have to find out, see 161 again,
Lordship. Is in 3 months, he has to file application.
161. Affected person. So he falls in the affected person.
Yes, Lordship. There is
3
no.
months. 3
Yes.
months.
Yes.
Right. And this order has to be passed, this has to be decided. 161. Now come to rule 142.7. One forty-two seven.
Order has been passed in accordance with the.
142.7.
142.7, where the order uploaded on the system has been. withdrawn. The summary of rectification of the shall be uploaded regularly by the provision of the proper officer in form GST DRC 8. This rule is also silent about.
Suppose he sits on the revocation application. And he also remains with the belief that his revocation application is will be allowed. Then what will happen?
Confirm? Yes.
By the time, if the assessing officer, proper officer decides it after 3 months, he has the right to file the rectification application within 3 months.
Yes, Lord.
Similarly, he has a right to file an appeal within 3 months,
Yes, Lord.
but he prefers the rectification application.
Then in my.
By that time, this proper officer sits on it. By the time statutory period of limitation would be over. And there is no prescription that this proper officer has to decide the application within 1 month.
Particular period.
That is also not there.
Yes,
If he sits on here, fortunately, within 1 month, he has been decided. That application has
That
been
is
decided.
altogether different.
But if he sits on it,
Lordship, correct.
and by the time with that, he allows that 90 plus 30 days period to expire, giving no scope for the appellate forum to condone the delay, what will happen? Everything is closed.
There are some judgments. It says that the affected party will get the benefit of that period also. There are some judgments also there.
So otherwise, without authority, I have to.
No, Lordship.
think it originally,
Lordship,
as I am thinking now.
my Lordship is very correct, and this is my submission also. But subject to whether he has filed an application for.
And is there any provision in the CGST Act that when something is stayed, that period will be,
Probably that provision.
which
is there.
provision? So means.
Yes, sir, that is there.
Then I'll stay this. I know, I don't know the exact provision.
No,
It is there.
It is there, but.
Please show us.
Lordship, I'm finding out. But without.
It is beyond 164 somewhere.
It is there, Lordship.
It is there. As I have taken this kind of petition after a gap. That is there. For the government, for the jurisdiction, levy of fee, rectification of. Protection taken disclosure. Yes, Mr. Bhuya.
Yes, sir, Lordship. I'm just.
Compounding offense, offenses by companies, presumption, cognizance, liability, punishment, confiscation, definitions, or waive penalty, waiver of penalty, discipline, related penalty, general penalty, fine for. Period of stay. Somewhere it is there, Mr.
Lordship,
Kayal.
actually, today I'm difficult to find, but in income tax, there is a specific.
No,
provision.
here also
Yes, in GST.
I
also.
think the period of later, what is the what is the relevant rules?
I'm not finding out it.
Which 107 relevant rule will be 108. 108. Come back after some time, otherwise we will not.
Lordship, this petition may be disposed of relating the matter to the first appeal authority to consider the case of the petitioner in view of the order passed.
No, because we have, in absence of any precedent, we have to do it,
And
right?
Lordship, then
That I need that provision so that if it goes against him, so that he will have the opportunity of the filing the appeal within time. And if something is stayed by the High Court or Supreme Court, I have seen some.
yes, it is there, Lordship.
Then that period will be,
Counted.
will not be counted.
Excluded from the.
So that he does not lose the right to file the appeal under 112.
No, 112, Lordship, I've given a notification. Lordship, until 30th of June, the order is passed before 1st of April 26. Then they are, they have given liberty to file appeal within 30th of June, Lords.
We would have trouble on cases. Government have notified that 30th June as the date up to which appeal may be filed before the appellate tribunal. In respect of all cases where the order sought to be appealed against it is communicated to a person preparing the appeal before first day of April.
Yes, Lord. Here it is in the February. Appellate order
19 February.
19-2. He is protected, Lordship. This interest is protected, Lord.
Let us have it on Tuesday.
Not.
You get the, you
Not
keep that provision.
Yes, after Tuesday. Tuesday, I have some part matters.
Okay, Thursday.
Yes, sir. Probably.
Because this question is basically as per the provisions of the Act. So we can decide it at the motion stage.
Lordship. And Lordship, benefit has been given to the appellant too, whose appeal has been decided before first of appeal. They can prefer appeal under section 1 and 2 by 30th of June. Lord. That liberty has been given to the.
But if this petition is to be allowed, that on the point of limitation,
Yes, Lordship, that is.
then it will go back to the first appellate authority.
Yes, that is.
And they can decide it on merit.
Yes, Lordship.
Right,
Yes.
that is the implication. So
And
it would go back, it
Yes,
would be, the order would be set aside.
it will go to the appellate authority.
First appellate authority, thereafter they have the second appellate authority.
Yes, Lordship, that.
If they decide it on merit, but
Yes.
here is a question on barred by limitation, whether that is correct or not.
Probably my submission, Lordship, that is not correct.
No, ordinarily, in common sense, it is not.
He will get the benefit of that rectification.
I think when a right is provided under that.
Not. I'll come with the order.
Okay, I, Bhuya, petitioner, SC Kyle, I got to repeat, raise the case on Thursday for further consideration.
Lords.
Much obliged, Your Lordship.
It's seeking apology, Lordship, in respect of item number 15, Lordship. 15, Lordship, morning, Lordship, petitioner side have mentioned, Lordship. In this case, Lordship, we have not given the consent because, Lordship, our railway goods are just blocked, Lordship. We have retained some, Lordship, cement, perishable goods in lien, Lordship. Urgency is in our part, Lordship. Interim is operating, Lordship. We have raised a question regarding maintenance or repetition. Lordship, the alternative remedies there before the RCT, Lordship.
No, they mentioned it with the consent.
Lordship, we have not given consent, Lordship. So Lordship may
Call the council.
Lordship may posted the matter my lord may posted the matter next week, Lordship. Any date fixed?
No, I passed an order
After 2 weeks, Lordship.
to call the council
Lordship.
to rectify the order.
Lordship. Apology, Lordship.
Because we are under the belief that consent has been taken.
Yesterday evening, they have called me, Lordship. I have not given the consent, Lordship.
But I don't know.
I have not given the consent, Lordship.
Next,
Lordship.
please call the council.
Lordship, I'll call.
Item number 19.
Oh, it would notification. Sorry, it would. When is your order in appeal was passed?
Order in appeal, Lords, it was passed on 17/3, 25, Lords.
So you have the right to appeal up to 30th June.
Lords, yes, I have the right to appeal, Lords.
It is by the notification. So you should approach. The violation of natural justice, whether that is there or not, that can be, thereafter you can very well come to this court. These are questions of fact and law, not a pure question of law. So let it be there. Who can call for the records? The appellate court can call for the records, examine whether you have filed all the documents or not, those were not considered. Then they can set aside the order, appellate order, right? Particularly repeat করিব as per notification bearing number S fullstop O fullstop 4220 within bracket capital E, which has been exercised, which has been issued in exercise of the powers conferred by subsection 1 or dated 17/9/2025, which has been issued in exercise of the powers conferred by subsection 1 of section 112, CGST Act, an appeal can be preferred in respect of a case where the order sought to be appealed against the assessee is communicated to him before 1/4/2026. Within on or before 30/6/2026. Full stop. The order in appeal in the instant case was passed on 17/3/2025, and as such, the remedy is available to the petitioner to prefer an appeal under section 112 CGST Act on or before 30/6/2026. In such view of the matter, this writ petition is not entertained, reserving the liberty to the petitioner to prefer the appeal under section, to prefer an appeal under section 112 CGST Act before the appellate tribunal on or before 30/6/2026. এখন সেইটো কেছত সোমাই থৈ দিব, ইয়াতে অৰ্ডাৰটো পাছ কৰাৰ পিছত।
Daily list for impediment of party, item number 2.
Yes, Mr. Borua.
My lord, your respondent has been changed, my lord. So I want to implement the new respondent.
Yes, Mr. Bora.
I have no difficulty in implementing, but however, my lord, the order has not been served on the newly implemented. They're trying to implement the newly implemented.
I will serve a copy.
No, it is
first you need to serve a copy.
because at least he has to be given the opportunity to comply with the order.
Yeah. Actually, they have submitted that compliance order is there. So to that effect, the list has to be produced.
But the procedure requires that the order which is alleged to be contravened is to be brought to the notice of that.
So may I give a liberty to personally serve to this?
How can it be? This is contempt jurisdiction.
Contempt jurisdiction.
Okay, my lord, then.
I am closing it, giving the liberty to bring it to the knowledge of the incumbent. Or you can seek withdrawal with the liberty to file a case.
She may be included, then I will serve copy.
No.
First it had to be done.
The condition precedent is required to be satisfied.
So
satisfied?
Yes, Notice may be issued immediately.
Oh, no. What Mr. Borua, what I am indicating is different. You first bring it to the notice of the alleged container. They have to file a IA for his implement.
So next week that may be fixed, I will start.
So that is not the way. There has to be environment.
First, last, okay, that's they inform me.
Since you have not understood, then I am deciding it.
Yes.
You have not understood, I am deciding it.
Then my lord, it should be posted for after 2 weeks. I
am deciding the application.
Yes, I will bring that.
Have you understood or not?
I understood.
That the decision is dismissal. Would you want a dismissal or something else?
My lord, something otherwise. I will.
Please make him understand.
Then whole contempt proceeding will close.
How can it be? This is IA only.
Then my lord, I will file IA after that. That will be done. My lord. 2 weeks may be granted.
No, not required. You have enough time. Whole year is available to you. First, you bring it to the notice of this
Yes,
dismissal or something else.
Withdraw, I withdraw.
MJ Borua, Learned Counsel for Petition, and Mr. S. Bora, Learned Counsel for the respondent number.
The sole respondent.
No, you are not appearing still now.
No, I am not, but sole.
No, how can you appear?
Here I am not appearing, my lord. Here I am not appearing, my lord. Not in the
Who was the earlier one?
Earlier I am appearing.
He is the sole.
Okay.
Here I am not appearing.
Has submitted that. He may be applicants may be permitted to withdraw this interlocutory application in order to bring the order alleged to be disobeyed. Alleged to be disobeyed in order to enable him to bring the order, alleged to be disobeyed, to the notice of the proposed party response. In view of the above submission made by Mr. Borua, this interlocutory application is allowed to be withdrawn. The liberty to file interest after compliance of the required formalities.
Item 3 for admission.
Manot, here, the petitioner has a claim, Manot, against the Central Register of Cooperative Societies. Petitioner has a claim against the Central Register of Cooperative Societies. Here is the case, Manot.
Claim against
Central Register of Cooperative.
Senior.
No, Central.
Central Register of Cooperative Societies.
Okay.
So here is a case, Manot.
Well, just a minute. Where is the petition?
Total 5 petitioners are here. All are family members, Manot. The petitioners
Just
are
a minute, Mr. Islam. Sir.
2023, there was the direction of the Honorable Supreme Court, Malord.
Noble Kumar Jha. Just a minute, Mr. Yes.
So. A direction was issued by the Honorable Supreme Court, my lord.
Where is that direction?
Lord, you will find the direction,
Lordship in
page
page
298, my lord.
98.
298,
299, your lordship.
299.
Just a minute.
Of 44.
Operative portion is in lordship, page number 302.
298.
299, your lordship.
299.
That is an IA, lordship.
Fine, be transferred to the central, which who in turn deposited paid to the genuine depositor, you must transfer. Yes, this is the direction. Then what happened?
So, my lord, the petitioners, after the direction, my lord, made some representation before the authorities, my lord. The respondent number 2, my lord, for disbursement of the money. But they have not considered or acted on the representation of the petitioners. So, my lord, the petition has approached this court, my lord.
Yes.
Now, during pendency of the present writ petition, my lord, the respondent side was directed. Earlier, my lord, there was a connected matter also, my lord. That connected matter already has been disposed of.
Mr. Das, you appear for?
Respondent number 1 and 2, your lordship.
1 and 2.
Madam appears for respondent number 3.
She is CB.
CB, lordship. That is the similar order, your lordship.
Petition, an order was passed by the Honorable.
Oh, that's my order. You were there. You were the counsel.
Yes, I was there.
All the same counsel.
Priyanka Prasad, 5269, 2025.
But in this case, my lord, the case, they are the, that in that
Is
case.
there
my lord,
any counter here?
counter is. But the extent of the SEBI is clear. The extent of the SEBI is that, my lord, as per direction of the Honorable Supreme Court, they have transferred the fund to the respondent number 2, my lord.
By SEBI, counter is by SEBI.
Yes. And secondly, my lord,
Just a minute, 336.
in the earlier writ petition disposed of by this court, my lord, in that writ petition, the claim amount was only 1,30,000. So that could be that was disposed of only because there was a, my lord, online portal, my lord, for submission of the claim, my lord.
Whether that is still functional?
Yes, Lordship.
It's still functional, but the limit is only up to 5 lakh. Only up to 5 lakh.
Lordship, if I may submit, Lordship, what happens, Lordship? There were cooperative societies was granted 5,000 crores initially to disburse the amount to the genuine investors after scrutiny. Therefore, they have established one portal. On that portal, Lordship, all the investors has to submit their documents, requisite documents, and after that, the cooperative societies will refund the money to them. What happened, Lordship? Initially, 5,000 crores was given, and and time was extended till 31st of December 2025. Thereafter, by this order, Lordship, again another 5,000 is transferred to the cooperative societies, and they are on a time is extended till 31st of December 2026. And this time, they have increased the cap. It's a verbal instruction from my from the department. They have increased the cap to 10 lakhs. The only motive is that, Lordship, that before there was 50,000, thereafter it has increased to 5 lakhs. Now it has the cap is increased to 10 lakhs. Only the motive of this because
small investors are to be paid
exactly,
first.
Lordship. Exactly, Lordship.
Medium class,
exactly,
next category.
Exactly.
Big investors are to be paid at the last because they are rich.
Exactly.
Your client is rich.
So here,
that's why, Lordship, the
So now your turn has come.
grievance has been
Now your turn has come.
no, my lord, here is the case.
No, now the cap is not there.
Yes.
How much you have invested?
now,
Total 7-8 lakh. Man.
So it comes.
no, it is 5 different petitioners, Lordship, 78 lakhs. A single petition, I think 26 lakhs. No, at that one, in the highest is 26
16 lakh,
lakhs.
20 lakh, 26 lakh up to this different. And secondly, my lord, in the earlier writ petition that was disposed of 15th of September 2025, my lord. And the claim was submitted in the month of October, my lord. So I have the documents also, but I have not done right now. But till now it is more than 8 months. Almost more than 6 months, my lord. But the money has not been
Big number of investors. They have to take care. Anyway, it is supervised by a retired judge of the Supreme Court and a
No, I
council.
want that, my lord, a direction.
Now your limit, okay.
A direction be issued, my lord, to the respondent so that I will submit all the documents
Highest is 26 lakhs.
in visible mode to the department.
If he's otherwise, please give a reason. Why
Lordship,
this
exactly,
26?
Lordship, my department had asked me, Lordship, to take 4 weeks time so that to get come to the final solution. They are going to file a parawise comments, Your Lordship.
Okay, then we put it
And Lordship,
on
this
it.
this is the latest
Third,
order.
Mr. M.A. Islam, learned counsel for the petitioners. Mr. D.J. Das, learned central government counsel for the respondent number 1 and 2. And Miss B. Chori, learned senior counsel for the respondent number 3. First of para. The petitioners, 5 in number, are from the same family who had invested. The petitioners have claimed that they had invested amounts of, they had invested rupees 26 lakh 75,686.60, rupees 17 lakh 35,000 874.10. 13,36,600. 16,64,600. And 4,44,500. That is rupees 78
lakh 57
lakh
57,000
57,216
260
60 in total. A table kekhon ase ate petition tar pa sai compile. In respondent number 4, during at different times.
Yes.
Full stop. The petitioners are seeking a direction to the respondent authorities, more particularly the respondent number 4, to disburse their invested amount in terms of the direction
of the Honorable Supreme Court
directions made by the Honorable Supreme Court of India in an order dated 12/9/2025. 12/9.
This is the latest order, Lordship.
Okay. Where is that order?
29.
Okay, I have got. Made in an order
That is in page
dated
302, Lordship.
29/3/2023. In the case in read petition C in IA number 56308 of 2023 in page 298 order, sir. Read petition C number 191 of 2022 within bracket Pinak Pani Mohanty versus Union of India and in a matter of Union of India through Ministry of Cooperation. Post of para within bracket annexer 7. Post of by the said order, by the said directions, comma, the respondent number 2 was directed to pay the amounts to the genuine depositors of the respondent number 4 out of rupees 500 crores, 5,000 crores, transferred to the respondent number 2 at that point of time, at the earliest, but not later than 9 months from 29/3/2023. Full stop. Para. Mr. Das Learned CDC, appearing for the respondent number 1 and 2, has submitted that the sum of rupees 5,000 crore, deposited with the respondent number 2 at the time when the order dated 29/3/2023 was passed, had been disbursed to a number of genuine investors after due identification. Full stop. However, at a later point of time, another
5,000
amount, another 5,000 crores has been transferred to the account of the respondent number 2 and considering the said fact, comma, the Honorable Supreme Court of India in the case of Pinakpani Mohanty Supra has passed another order on 12/9/2025. Post of. He has submitted that by the order dated 12/9/2025, comma, well, he has submitted that from the order dated 12/9/2025, comma, it transfers that approximately 32 lakh more investors are expected to file claims in the portal, and therefore the Honorable Supreme Court has directed to keep the portal open till December 2026 to enable the genuine investors to file their respective claims. Right?
Lordship.
Post up. Mr. Das has sought for 4 weeks' time to obtain definite instructions as the claims of the petitioner herein are beyond a certain limit. Post of. Considering the submissions of the learned counsel for the parties, let the case be listed again. First week of June.
Fix a date, madam.
1st of June?
1st of June.
1st of June?
2nd of June, madam.
Can it be a second week of June, your lordship?
9th of June.
9th of June, lordship. Much obliged, lordship.
Hello, madam.
Oh, before that, one more. Mr. Das has submitted that in the first round,
Already 5,000 crores have been disbursed.
for disbursement in the first round, no, from the corpus of rupees 5,000 crore deposited at the first instance, comma, the amounts deposited by small investors, the mandate was to release, disburse the amounts to the small investors.
Small investors. Lordship, much obliged.
6.
Mazur that's for submission.
Well, this is relating to unauthorized encroachment of the petitioner's land by the respondents in the name of a ongoing project. It is namely bank protection.
You are supposed to file any additional
It takes time, 2/4. By the day, order was given from the Honorable Court to file a detailed additional affidavit regarding filing of this the title aggregation case last order and the map, concerned map. So I have filed on that day. They took time to respond that this.
You would like to file an affidavit of opposition to the additional affidavit. Okay, you filed additional affidavit.
Yes.
They took time to file additional affidavit of opposition.
Yes, my lord.
Actually, my lord, this affidavit was not available with us that day. So now, after going through that affidavit, additional affidavit they have filed, the stand taken by them is that the land in question was handed over to them by way of in execution of a decree. Now, my lord, after going through this, we find that the land which has been mentioned here in the decree, which has been handed over, although this was ex parte decree, looks like my lord, a consent decree, decree for specific performance of contract, and subsequent it is ex parte, and then decree the position is handed over. Although we are not concerned with this because this content refers to DAG number 145. And the project which is in question, this is in completely separate dark, that which has been taken stand by the Water Resource Department as well as by the government. My lord, I have also other day, my lord, lordship wanted to know the revenue clearance, my lord. The record from the Revenue Department also says that it is in the dark number 182. And no way petitioner's land is involved. We all have made a my lord, analogous stand in our affidavits that petitioner's land is not involved in the project, my lord. So therefore, my lord, in my humble submission, this is purely a disputed question of fact which has to be ascertained by a competent civil court, my lord.
So whether you want to file any affidavit in opposition?
If your lordship,
Because otherwise,
if required, my lord, we can file. But this fact remains this, that this is that a completely different land, my lord.
My lord, they kindly
make a statement then, make a statement.
I'll just make one submission, my lord.
If we find that it is disputed question of fact, that is a different matter.
The dispute is raised by them, my lord.
Let us,
They have raised,
yes,
but
let,
thing
let,
is that
let us
they-
hear
whatever-
Mr. Das.
My lord, but
Let
whatever
us hear Mr. Das.
lord.
He wants to say something.
My lord,
In our affidavit, we have clearly stated, my lord, in the para 3, that the ongoing the beautification project took place in the government land. That is, my lord, government doc number 182. And my lord, with regard to that, they file an additional affidavit stating that, my lord, that is page 70, if your lordship come to para 5. It says, therefore, whatever the statement made in the behalf of the respondent number 2 in para 3 of the affidavit in opposition filed on 5/8/2025 that the ongoing project is carried out by the Water Resource Department is executed confined to the government land under doc number 182 of village Gotlong is totally false and misleading statement. If that is kind of false or misleading statement, it comes under the purview of my lord, disputed of facts, my lord. It can be only, my lord, what I feel, my lord, what my submission. Civil court may be the competent, my lord. Either to go and say that this is, they have then my lord, trial can took place, evidence can be placed. Otherwise, my lord, again, if you go for the, my lord, the affidavit, it will come with the same stand, my lord. It will say that there are
No, we will record that you are, if you do not want to file any affidavit,
No, we'll
because
put it
on the
on
last
record,
occasion you
madam.
sought time.
We'll put it
Right,
on
to
record.
file a affidavit in opposition.
We'll file.
Right, if you don't want to file, I'll record it. Then we'll proceed. That is the matter.
yes, my lord.
Otherwise,
Just
you will
file it.
say that it was recorded. Tell me either this way, you want to file affidavit or do not want to file affidavit.
File it in
Accordingly, I'll record so that we can proceed. But what do you do?
I'll file affidavit, my lord.
You will
Next
file.
week, yes.
You as a standing counsel.
Water resource.
Water resource.
Okay, that means
I'll go in.
1, 3, and 4.
Yes.
Yes, Mr. Das.
I am for 2 and 5, my lord.
Yes. Any requirement to file any additional affidavit to the addition?
Will
Tell me, I'll record. That's all.
then will be same, but
Same.
I'll seek the instruction. If any instruction.
Don't seek instruction more. You have already sought time.
My lord will file affidavit. Let it be on record. my lord.
File, we'll fix it on a fixed date. If you file or not file.
Yes, yes.
Thereafter we'll decide. Otherwise,
Yes.
But brother, my lord, in earlier occasion, I filed an application for appointment of the commission, my lord. The commission will decide because it is
so
not
that
the.
we'll decide after that.
Yes, my lord. Because all
Let
the
them
time I
file
am
it.
deprived from my right of the property, my lord. This is not a disputed fact. It cannot be raised at this stage.
No, we are not right now. We are not
Yes.
inquiring your extinguishment of your right.
Yes, my lord.
It is open still.
Yes, yes.
Heard Mr. P. Mohantal, learned counsel for the petitioner, Ms. P. Chakravarti, learned standing counsel for the respondent number 1, 3, and 4, and Mr. N. Last, learned junior government advocate for the respondent number 2 and 5. Who is respondent number 6? And Ms. N. Border, learned standing counsel, Revenue Department for the respondent number 6. Both Ms. Chakravarti and Mr. Das have sought further 2 weeks.
I can file it within 2 weeks.
Because
Yes,
of-
Mr. Das.
3 weeks.
3 weeks.
No, my lord, 2 weeks, my lord, because
3
already.
weeks time to decide whether they would file any affidavit in opposition to the additional affidavit filed by the petitioner and to file a same. And to file a same. Post up. The price allowed, release the case. 3 months.
1st June.
First.
1st of June. My lord, my humble one prayer, my lord. On that day, they should come with the all my lord preparation. They cannot take for another time because my lord, my
That is
ears
why,
already.
Mr. Mohanto, that is why I say take a decision to file affidavit of opposition and to file the same.
Yes, my lord.
That will then at that day it will be closed.
But then
Then it will be closed.
then the maintainability I will come because my lord, the all the maintainability.
I am not applying my mind, so
Yes, my lord.
keep your energy reserved.
Yes, my lord.
Keep your energy reserved.
Listen, my lord, this Bombay police case also it is decided by the Honorable Supreme Court, my lord.
My lord, if we fail, we'll argue the matter.
7. Item 7.
May I please, your lordship? My lord, in this writ petition, I am praying for setting aside of a Lok Adalat award, my lord. That was the last date, respondent number 15 made a submission that although being the power of attorney.
Iqbal.
My lord.
Here, let us see the parties. You are for a petitioner.
Right.
Okay. 1 to 6 is represented by respondent number 15.
Yes, my lord. My lord, we
Yes.
have obtained instructions, my lord. We are for respondent number 15. My lord, we have received the power of attorney to appear on behalf of 1 to 6, my lord.
Okay.
Yes, my lord.
Okay, 1 to 5. Okay. So, affidavit in opposition by respondent number 5 will suffice? Already,
my lord.
your respondent number 15
Yes, my lord.
has filed an affidavit.
Yes, my lord.
Whether that will be the stand of the respondent number 1 to 6.
Yes, my lord.
And who is for the other respondents?
My-
7? 7 to 7, 8. 11 to 14. What about 9 and 10?
They are not represented, my lord.
Huh?
They are not represented.
No, whether service is
Complete, my lord. Complete.
Huh? Let us see. Ukalnama sa ukalnama. Ukalnama. Yes.
My lord. So, my lord, the matter here is the respondent numbers 1 to 6, represented by respondent number 15. they instituted a suit. Being the plaintiff, they instituted a suit against respondent number 7 to 14 as defendants. And my lord, the matter has been resolved in the Lok Adalat and an award has been passed whereby the entire land in dispute has been divided into almost 3 equal proportions. Now, my lord, the petitioners herein are the legal heirs of a pattadar who was not made a party, nor were the petitioners made party in the suit.
Or is your supporting document?
My lord, the Jamabandi, my lord. My lord, the type copy of the Jamabandi starts at page number 26. And my name appears at serial number. Our name appears at serial number 20.
This is a downloaded copy.
My lord. Download copy.
Do you have the original certified copy?
Certified copy I don't have, my lord, now.
Huh?
I don't have it now, my lord.
Because otherwise this may not have any evidentiary value. This is a Jamabandi.
My lord. I can get the certified copy.
Because I have already recorded your case in the first order
Yes,
with much pain.
Yes, my lord.
But that is your claim. But how you substantiate that you are, where is your order, relevant order in the Jamabandi?
My lord,
On the right side,
on the right side,
which page?
it is page number 29, my lord. 29.
20. Your serial number is from? Tell me the serial number.
My serial number starts 20 in the Jamabandi, Mrs. Jyotika Teron. My lord
This
is
is-
taking the type copy.
Page 28, I am looking at
20,
type.
yes.
This is type copy.
Yes.
Where is the downloaded copy?
Downloaded copy starts at page 30.
Page 30.
30. And my name appears at serial number 20.
His 20 is petition number?
Petition number 1. Srimati
And-
Jyotika Teron.
And
Petition number 2, Priyanka Teron. Petition number
just a minute, just a
My
minute.
lord.
Don't go for so fast.
My lord.
Yes.
My lord. My lord, serial number 20, Srimati Jyotika Teron is the petition number 1 here. Then number 21, Priyanka Teron, petition number 2. Serial number 22, Sri Digombo Teron, petition number 3. And 23, Sri Torulota Teron, petition number 4.
4. Total 4 petitioners.
4 petitioners, wife and son and daughter.
Corona Kanto.
Petition only.
So and so. So petition number 1 is wife of Corona
Wife of
Kanto.
Corona Kanto.
Corona Kanto.
Yes, my lord.
Petition number 2,
2, a daughter.
daughter.
3, son.
3, son.
And 4 is again daughter.
Daughter.
Daughter, small daughter.
Where is the remark?
My lord. My lord takes page number 33. Hukum number Sokro Bikhoya 21-23. May I read it, my lord?
Okay, do you have the copy of this order? Have you annexed?
No, my lord. That is not annexed here.
And because that order is required, otherwise this is a downloaded copy.
My lord.
Jamabandi. That is for the purpose of depositing revenue,
My lord.
not regarding title.
Agreed, my lord.
Right. So where is that document, say, Corona Kanto Patta? Do you have any Patta?
Patta,
Should in your favor.
they will,
These petitioners are in the name of Corona Kanto,
they must, I'll have to take instruction on that.
plus the mutation order.
I'll get that, my lord.
Because you are seeking setting aside of a local award, which amounts to a decree.
My lord. My lord.
Right. That is a serious matter.
My lord.
nullification of a decree is a serious matter. Let us see their affidavit. Who else have filed affidavit?
My lord, the stand taken by respondent number 7 to.
Who has filed affidavit? Tell me first.
7, 8, 11, 12.
Respondent number 15. I have found respondent number 15.
My lord.
In instruction of structure, no? Whether they will get authority or not.
Where is the Lok Adalat award?
My lord will find it at page number 13, my lord. This is a type copy, my lord, and the original starts at page number 16.
Where is the schedule to the plaint? Schedule to the plaint.
My lord will find it at page number 20. Schedule to the plaint, my lord.
Because Lok Adalat mentions about schedule to the plaint.
My lord.
It mentions nothing about dag number, pata number, location.
My lord, the schedule is at page 20 of the
That
Lok
is what
Adalat.
I am looking at.
Page 20, my lord.
And who else have, okay, 7, 8, 11, 14.
My lord.
Yes. Have you responded to paragraph 6 of the affidavit in opposition of the 7, 8?
My lord, I have not replied, but I would like to orally submit, my lord. This paragraph number 6. Here it is said that Marmot Teron got his name mutated by false means. Now, Marmot Teron is the father of Karunakanto Teron. And it is stated that Marmot Teron had no right in the scheduled property, so Karunakanto Teron will have no rights. Now, my lord, interestingly, defendant numbers 3 and 4, who are respondent numbers 9 and 10, are also son of Marmot Teron. And they got a share as per the Lok Adalat award. That means, my lord, Karunakanto Teron was deliberately kept aside in this suit, my lord. And this 10 comes from the defendants, my lord, not from the plaintiffs. Defendants say, I have no rights.
Well, you are for sitting aside of the award,
my lord.
then you have to, this would go otherwise. This will remain. Why you are not responding it?
My lord, this is a contradictory statement that they have stated because two sons of Marmot Teron already got a share as per the Lok Adalat award. How can the third son be left out?
No, you have to make a statement, sir.
My lord.
It is not that by oral submission something is.
Well, I'll bring it in the.
You are sitting aside of a decree
My lord.
in writ petition.
My lord, in that case, I'll bring it on affidavit, my lord.
And plus the mutation award order.
I'll get it, my lord. And the patta, my lord.
Because it is serious matter otherwise.
Yes, my lord.
Allegation is also serious, and if that has been done in the Lok Adalat, that is also serious.
Yes, my lord.
They admitted that you are the legal heirs of Karunakanto.
Yes.
But they have disputed about Karunakanto.
Yes, but.
Right.
Yes.
Tracing your history to Marmot Teron.
My lord.
Right. And say that Marmot Teron never owned any portion. But you say that some 7 and 8 are sons of
Marmot Teron.
Marmot Teron.
My lord.
Make a statement.
Yes, my lord.
Where from otherwise I'll get.
My lord, I'll make that, my lord. And my lord, interestingly,
These are intricate things that requires statement on oath.
I'll do it, my lord. I'll do it.
Tomorrow it turns out to be wrong.
My lord.
Then you will be held guilty.
My lord.
Yes, mister.
Correct. Since we are in a writ proceeding,
It has
Ah.
to be based on pleadings, my lord. Whatever
Yes.
decision comes
Yes.
from this honorable
If
court.
it emerges because partly they have admitted that you are the legal heirs of Corona Kanto. But with some twist, they said Corona Kanto's credential is doubtful.
Doubted.
But if you say 7 and 8 have also got a piece of land
My lord.
by way of inheritance, and they are the brothers of Corona Kanto,
My lord.
and their inheritance is from Mamot.
Mamot Terror.
Make a statement to that effect
My lord.
to belie their contention. Otherwise, it will be difficult
My lord, I'll do
for a read court. Go by the oral submission of the council.
My lord.
Yes, you represent whom?
Lord, I was asked to assist the honorable
Okay.
court regarding, my lord, the maintainability of the
Okay.
regulations.
What do you say? Maintainable or not maintainable?
Maintainable, my lord. I have already placed one judgment, my lord, Dilip Mehta.
Dilip Mehta, Bhairavi.
Yes, my lord.
Bhairavi is also.
Bhairavi is also there. Dilip Mehta versus
Line-
Bharat Gupta. This is the recent one, my lord, 2025.
Show us.
Yes, 2025, SCC online 2737.
But the family tree is to be asserted, right? Then I can give an opportunity to the other party for 1 week to dispute that.
Okay, my
Get the mutation order,
Yeah, I'll get it.
right? And original copy of the Jamabandi,
Sir,
get it and next. These are downloaded, right?
Yes, my lord. I'll
They
get
have
the
no
certificate.
evidentiary value otherwise
I'll get it, my lord.
in the eye of law.
Understood, my lord.
And thirdly, the controvert the statement.
I'll
If
do it.
you have material to controvert, paragraph 6.
I'll do it, my lord. I'll do it.
Yes, anything to say?
My lord,
We are not deciding today.
Otherwise, the petition
We
does
are not
lie.
deciding today. Yes. What?
No, this disputed
Maintainable or not maintainable?
not maintainable because this is disputed questions are there. Even in their own writ petition, para 8 last part, kindly see
And
that-
what else, what remedy is there, Mr. Das?
If we go by the law laid down by the honorable apex court, REIT is the only remedy, my lord, in this type of matters, my lord.
the title should is the remedy.
Think about the other remedy.
Yes, my lord.
In a case of this nature, it may not be the only remedy.
Fraudulent.
Whether a decree can be challenged in another suit on the ground of fraud by a third party.
Yes. Hello, sir.
Heard Mr.
A Khan.
A. Khan, petitioner. M.U. Mahmud. 378 11.
No, I am for 7, 8, 11, 12, 13 and 14.
7, 8 and 11 to 14.
11,
To 14.
no, 11, 12, 13, 14.
Huh?
Yes. Yes, 11 to 14, yes.
And Mr. G. Imtiaz, learned counsel for the respondent number 1, 2, 6 and 15.
Yes.
Also heard Mr. H.K. Das, learned amicus curiae for the ZHE. Post. Para, Mr. Khan, as sought for by him, is granted. How much time?
2 weeks, my lord.
2 weeks time to file an addition affidavit in reply to the affidavit in opposition of the respondent number 7, 8
11 to 14.
and 11 to 14. Full stop. The president leaves the case on so.
3rd June.
Continue.
Intimate.
Your name is reflected, Mr. Das?
Yes, please. Name is.
Oblige, my lord.
From that side, other side.
Go for it.
I'll do. Last occasion also, they have take times 2 occasions lawsuit, although court has indicated lawsuit.
Lordship, yesterday I had informed learned counsel that we'll be seeking time in
Mr.
the.
K. Gugoi, Naya Center, episode, Mr. K. Gugoi. Naya CGC. has expressed urgency in the matter. List the case on so and so. Interim order passed shall continue till the next stage of listing. 18.
Before that lordship, possible lordship, before that. As because lordship, railway yard is lordship, block lordship, we cannot loading and unloading the. 15 lordship.
Oh, much obliged.
Obliged lordship.
Yes.
Instruction যদি আহিব লগা নাই কিন্তু এই নহয় সেইটো আজি ডিসপোজালৰ কাৰণে লাগিছে এই ভুলকে লিখছে নেকি
Impugn order at page 38.
Page
38.
কিনা নিবেদিত আছিলে ভুলকে লিখছে নেকি এইটো সেইটো কথা নকম ন এইখিনি লাগে আগৰ এটা অৰ্ডাৰ এটা তবে হয়তো সিহঁতে ক'লে কি এভিকশ্যন টু বি কৰিব এভিকশ্যন নকৰি দেৰি আছে মানে সেইটো এতিয়া হেৰি ইছ্যুৱে থাকে
It is a society.
Society, my lord, what happened in this long pending case, my lord? Your lordship kindly have a look on page 15, my lord. Additional Deputy Commissioner wrote to Circle Officer to carry out the eviction operation in encroachment case number 1 of 2008-2009. That order page 21. Well, that letter was put in challenge in Board of Revenue, that was rejected. Then they approached the High Court on by WPC 3154/2009 as page 24.
Read petition.
At page 3154/2009, the writ petition was dismissed. Operative part at page 30, my lord, paragraph 9.
সেইটো এটা কোনোবাই দিম ৰেজিষ্টাৰ
Yeah, okay. Yeah, and good size. Come to page 27.
27, my lord. Yes, my lord.
Paragraph 3.2.
Ah,
Land was duly settled with deserving landless persons.
these are the society is a landless person, my lord, comprising.
Is there any order of settlement?
No, my lord.
Here?
No.
You are not enclosed.
No, my lord, this is, my lord, covered by all these judgments. There is an.
No, because whether this society is those settled.
Because in fact, in both, read petition, we are made party, my lord. Read petition, we are made party as respondent number 7, my lord. আমার কিন্তু আছে নাকি এই জিনিস প্রথম?
It has a long history.
Long history, my lord. Since 88, 89, my lord. Why not? I got 282.
7.
Later, my lord. Oh, in a Dhanikula, my lord. Lordship, would like to. Your lordship kindly page paragraph 29, page 29, paragraph 6.
I am reading that only.
Well, I have supplied a copy of that. It's a fine particular. It also reflect the same thing, you know. Got No, visual of me.
Yes, Mr. Borosaiji and Mr. Sharma.
Well, look, although I have not received any instruction as yet, only thing that comes to my mind, they could have been made respondent in the earlier proceedings, where despite whether we do not know whether it's a registered society or not, that can be, you know, as they are representing respondent number 7 only. But when they appear before this honorable court as a petitioner claiming some right, they have to show that it's a registered society, because there are other there are judgments of this honorable court where
are you a registered society?
And that is not there is no averment as such.
Registered society? Are you a registered society?
Because Meghalaya Drug Dealers Association case.
Sorry, my lord. But the settlement was made in favor of that society. You have not denied it, that portion.
So far as encroacher's situation is clear, right? But petitioner's
Right.
picture is not that
No,
clear.
petitioner, my lord, in fact, the order I got it, in fact, your lordship will find that also, the copy. It says that Pottomome Dolong Sorka.
That I have understood. But
Panbari
who are the families of 18? 20
Bidasto, Ban Bidasto.
yes, who are the 21 Bhumihin Poriyal?
Poriyal.
Who are they?
And they have,
Because
I have not.
no, situation may arise that somebody else may enter into the shoes.
My lord, my lord. Then
We want to
I understand
proceed
your lordship.
further
I understand your
for
lordship.
genuine
My lord,
persons. Because nothing is there about 21 families. By this letter, out of 47, 26 gone out. Remained 21 Bhumihin Poriyal, for whom this land, that earlier one, আবণ্টন পোৱা 31 পূৰ্বৰ আবণ্টনৰ 500 বিঘা মাটিৰ ভিতৰত অন্তৰ্ভুক্ত কৰিলে আৰু আবণ্টনীয় মাটি দখল it is not very clear.
No, I'll try to bring on record.
Because otherwise we have to ascertain that eviction process should be initiated only for genuine persons. Because nowadays, you know, who enters into the shoes of whose actually enter into the shoes, claiming that
I fully appreciate your
I am a successor in interest of this person, 21. All these are all old things.
I will try to bring on record, my lord, the list of members, original members, my lord.
Yes, they definitely we are interested for taking this to a genuine end.
My lord.
But question is so that our direction should not be misfired.
My lord, that problem cropped up because of earlier.
One, if the society is registered, it has the locus. And if the society is registered, it has a list of members.
My lord.
Right. A list of members of families
My lord.
who can be deemed to be treated as landless persons. Right. If society is basically registered. Right. So there are two things to it. One is to carry out the eviction process to evict the opportunistic encroachers. Next.
Genuine and proper person.
If I can say if there are genuine LOTs, then it should be handed over.
Regarding that second
After due verification, second part.
regarding that second part, there is no such prayer. Their prayer is only for an eviction of the encroachers. That part is not there.
Because allotment, settlement will be given by the.
Yes, Lordship. If it is found that they have been rightly settled, that is up to the government.
Up to government.
But that part is not there, Lordship. It is only for the eviction of the encroachers.
It is only for eviction only.
Eviction only. That is why, Lordship, I have not.
Then it can be only in terms of the direction. Where is the division bench judgment?
Division bench judgment at page
32.
30. Start from 32 is ended at page 36, 37 below.
Paragraph 936.
Yes.
Page number 36, paragraph 9.
Okay. So your stand in the affidavit is?
Lordship, I do not want to rely on it.
Both, I'll attribute words to both of you. Then we'll dispose of.
It can be, otherwise,
in terms of the prayer, because they are also interested party, because they were respondent in the writ petition as well as in the writ appeal. Right, so they have a right to pursue that the direction made or observation made by the single bench and the division bench should be taken to its logical conclusion. So that eviction process, there was no direction. That stand you have taken in the impugn order as well as in the affidavit, that appears to be wrong because eviction proceeding was initiated and the single judge and the division bench did not interfere with it, meaning thereby it has to be taken to its logical conclusion. Thereafter, we will not observe anything.
But then only thing that was bothering me, can they file in this way, madam? Who are they? The first thing will come. Who are they? Because when they come as a petitioner, they have to be a registered society, or otherwise the all individuals have to come. That is only my concern.
Okay. Are you a registered society?
Yes, there is also a judgment of the Apex Court, my lord. I'll satisfy your lord not now. That even unregistered society can file a petition.
But otherwise,
I had judgment, my lord.
Are you a registered society or not?
No, that is not clear here.
Huh?
I don't have any instruction to that.
Because you have set up a society, you said.
My lord, society name is society. That question was not neither put in the earlier.
So show me any of this petitioner is a genuine LOT. That's all. That will give you locus. That will give you locus to pursue.
I'll satisfy you.
Say any of these petitioners, notwithstanding petition number 1, other 2 to 5 are genuine LOTs, then they will have locus still to pursue the writ petition. That's all.
Yes. My lord.
Only thing, there should not be any.
I'll try.
Because lots of litigation have already been pursued. Let it come to a closure.
My lord.
But State Council has raised the issue of locus.
My lord, now.
Let us say.
Lord, though if there is nothing on.
Show us any of these petitioners
My lord, I'll try.
is a genuine LOT,
I'll try to get it.
or the petition number 1 is a registered society and land has been allotted in its favor. Either of the two. As Mr. Das had submitted before the appellate court, if something is there to substantiate, at paragraph 6 of the single judge or division bench, single judge, paragraph 6 perhaps, paragraph 6. He said, you are allotted the encroached government land to 47 flood affected freedom fighter.
My lord, my lord.
Right. Something
I'll be.
that will be very grateful,
Give me some
useful
time,
to the court.
Give it to some time. Lord, I'll bring it.
Then also that will also give rise to your claim after eviction.
Yes.
If you are genuine hard based, I would repeat for you. Mr. Kotoki has sought. How much time you need?
Sir?
How much time you need?
3 weeks, my lord, I'll ask them to inform Dorong now.
Short for 3 weeks time to file an additional affidavit to substantiate the claim of to substantiate as regards locus of the petitioners to pursue this petition and to support the claim of the petitioners that the petitioners are allottees of the parcel of land in respect of which the eviction process was carried out. Eviction process was challenged in WBC number 3154/2009 and writ appeal number 184/2015. List the case on soils. Just some document.
Mile. 3rd June, 0306. Item number 10.
In this case, as directed by this honorable court, my lord, affidavit we have filed, they have, I'm told that they have also filed their reply, my lord. All these are not before your lordship, my lord. So both of you have filed.
Also, one thing is that in the first order, because expected that directed to the enclose the copy of the award along with the affidavit. The first award, lordship, although we have received a copy of this, lordship, their opposition, we have not seen the lordship that they have annexed the award copy, lordship. So lordship, that may be at least lordship provided.
Rectified award has already been annexed there, my lord, in the affidavit. Yeah, we'll try to find it out also.
The first
Lordship will
award
take
is
it up after 10 days or 15 days, my lord. If there is any lapse in our affidavit, we'll try to find it out. Given record or 22nd. Award has been rectified. Yes.
the first original award is not annexed with the affidavit, lordship.
Lordship will hear the matter. Let us have the affidavits first. Yes. On record. Yes. You have filed reply also.
Reply you have filed also.
Okay. Heard Mr. J. Colita, learned counsel for the petitioner. Mr. B. Goswami, learned additional advocate general, listed by Mr. R. Kakoti.
P. Kakota.
P. Kakoti, learned counsel for the respondent number 4 and 5. And Miss Tin Lo, learned counsel on behalf of Mr. R. K. Talukdar. He is standing counsel. Standing counsel. NHIDCL for the respondent number 1 and 2. Miss N. Bordoloy, standing counsel, revenue for 3. Agua Pisha Koilo. Mr. Goswami has submitted that the affidavit in opposition of the respondent number 1 and 2, 4 and 5. Has already been filed, and the same is not on record. Similarly, Mr. Kolda has submitted that an affidavit in reply to the said affidavit in opposition of the respondent of 4 and 5 has also been filed, and the said affidavit in reply is also not on record. First of registry to trace out the affidavit in opposition of the respondent number 4 and 5 and the affidavit in opposition reply filed by the petitioner, and thereafter to tag the same with the case record. First of list the case on so and so.
May I pay one thing? They have rectified their first original lottery award. So this petitioner may be at liberty to approach to raise their objection under section 3.5, 3G lottery 5 regarding the award lottery they have. This petitioner may be at liberty to, they may be allowed to raise their objection before the concern regarding the award loss.
You can raise your objection. Even instead of coming to this honorable court, they could have resorted to the right is very much available with you. Yes.
2005.
Original award copy loss. First order there is a restriction loss. You got it first.
Okay. Whether that will be sufficient or not, we'll see, my lord. If necessary, we'll obtain it, my lord. If that is there, my lord.
That is necessary.
The respondents will make endeavor to place a copy of the original award which is stated to be rectified later on.
Lodge. 20 days.
Item 11.
Yes,
Wait,
Mr.
Mr.
Oscar.
This matter, can it be taken up after 25th, my lord?
Mr. Kolita. After 25th.
After 25th, my lord, 29, 28,
29.
29. Obliged.
29. Yes, Mr. Oscar.
This matter relates to acquisition of the land by the respondent authority.
Yes, Mr. Sharma. No
Lordship-
counter.
Yes, Lordship, we have not received the instructions. But in addition to that, Lordship, I think they have to, as because from the petition, it reflects that it is for construction of the national highway. The highway authority, Lordship, as because we are the disbursing authority, if the amount is paid to us, it will be, so
It
there.
is National Highway, Mr. Oscar.
National highway.
National Highway. Let us see the. Oh,
That is the, most probably they have to be made party.
Mr.
Ministry of Road and Transport and Highways.
Page
Page 19 is the notification.
yes.
NHAI is to be made. party.
Maybe NHAI or NHIDCL. We
yes,
don't know. Let us see other documents. Have you received any notice?
We have at page 35, your lordship. It was by the assistant settlement officer.
No. Yes, 34.
35.
NHIDCL. The schedule of land is to be acquired by NHIDCL. Just the line below that, serial number 63.
That is there. They are responsible for
Making the payment, we are only the disbursing authority, lords.
Let them,
under Bharatmala.
because this government authority, they have dispersed to some persons already. So let them file an.
And you come to page 39 also.
Lordship.
Which one is this?
No, this is
Different letter.
a different letter, your lordship. By way of this letter, this.
This NHIDCL is to be made a party.
That,
Otherwise,
Let,
it is a necessary party. It is a necessary party. You are seeking compensation
lordship.
or enhancement of compensation.
We are seeking compensation first.
Compensation. Then it has to be in the list of beneficiaries. They can only give the details.
They're in the list of beneficiaries for that.
And secondly,
For that, they have issued a letter. That
Kala has been made a party.
lordship.
Have you received any notice from Kala?
yes,
Competent
respond
authority.
number 4,
I
Additional
have
District
seen.
Commissioner Land and
I
Revenue.
have seen.
Lordship.
But have you received any notice from Kala?
Not yet.
With reference to the subject, we beg to inform that there has been a great disagreement related to continue. Yes, Mrs. Sharma, the page 27. If you read page 27,
Lordship.
it will be clear. Your claim is against DAG number 228. 228.
Page number 27, Lordship.
Your claim is against dark number 228.
Three DACs are there, 59, 223, and 228.
You own 59 also.
59 also. DAC number 59.
You have not made any complaint about 59.
No, it is there, Your Lordship. I have specifically stated.
Where it is stated?
Page number, paragraph number 9, Your Lordship. In their official record, they are showing that 10 kata has been acquired, while in fact 17 kata is acquired. Now, when we said that we have 17 kata, they said that no, initial publication, we have recorded 10 katas, but you have a separate notification, further 7 katas will be shown to have been acquired.
Heard Mr. M.H. Law School and counsel for the petitioners, Mr. H. and Mr. H. Sharma Leonard. Any CGC? No. Leonard, additional senior government advocate for the respondent number 3, 4, and 5. Full stop. The petitioners have claimed that they are owners, landowners of a parcel of land comprised are covered by tag number 59 or pattern number 35, tag number 223 or pattern number 35. And tag number 228 or pattern number 33. Situate in village Chandighat, Channighat, district Kachar. Para. It is the case of the petitioner that in the process of acquisition, land acquisition, initiated for a project, building within bracket, widening, stroke 4-laning, etc. Bracket close, maintenance, management, and operation of NH-306 in the stretch of land from KM 20+000 to KM 49+360 in the district of Kachar, initiated by the Ministry of Road Transport and Highways, Government of India, under the provisions of the National Highways Act 1956, page 19 of the 2 parcels of land belonging to a petitioner have been brought under its purview. Full stop. The petitioners have stated that altogether an area of land measuring 17 khata and 4 chatak have been acquired for the project. Full stop. It is the case of the petitioner that 10 khata of land falling within DAG number 59 of patta number 35 have been acquired. Full stop. In addition, 7 khata and 4 chatak from DAG number 223 of pattern number 35 and DAG number 228 of pattern number 33 has also been acquired for the project. However, in the notification published by the respondent authorities, respondent MOR PH GOI, comma, the name of the petitioners are not reflected in the list of beneficiaries.
No, it is reflected, Your Lordship. In the list, it is reflected.
For the entire 17 kata and 4 charak land. Partially reflected.
Partially reflected.
Also. Para Mr. Sharma, Land Relations Senior Government Advocate, has pointed out that the implementing agency for the project is National Highway and Infrastructure Development Corporation Limited, NHIDCL. And therefore, the NHIDCL is a necessary party in this proceeding for adjudication of the issues raised by the petitioners in this petition. Mr. Loskar, in response, Mr. Loskar has submitted that he will file appropriate pleading for implement of the necessary party, including the NHIDCL. Within 2 weeks from today.
In the meantime, they can get the response. The court has, they can get the response because competent authorities, they are.
They will come with a standing counsel and it will be easier. Otherwise, it will be fishing in a big sea. Release the case after 2 weeks. He filed a impleading application. Release the case after 2 weeks on a day to day.
Only one thing maybe
Let him file, then only you will proceed.
Only one thing may be mentioned, Your Lordship. Our fishery have also been acquired, but that is also not.
Oh, that will come later on. First, you make the necessary party.
Yes. Obliged, Lordship.
Item 13.
My lord, there's a similar case, my lord, pending. At least 1080 of 2026. My lord, we are going to file an affidavit along with that, my lord. May I list those matters together, man.
What is the matter about?
My lord, they are contending that one forest mineral settlement has been awarded in their patta land, my lord, but our instructions are contrary to that.
Mr. Bhattacharya. Yes, Mr. A. Bhattacharya, learned counsel for the petitioner, Mr. I. Bhattacharya, learned standing counsel, petitioners. And Mr. I. Bhattacharya, learned standing counsel. Forest Department for the respondent number 6. 5 and 6. M. Bormon 1.
3 and 5. Respondent 5 is actually union government's organization.
6. And Miss N. Bodule. Revenue 2. Okay. Mr. Bhattacharya's short listing of this case along with WBC number
1080 of 2026.
26. After 2 weeks, as both the writ petitions involve common issues and an affidavit in opposition a counter affidavit is going to be filed in within 2 weeks in WBC number 1080/2026. So, list the case on after 2 weeks. Will give
1st June 0106.
My lord, this case is listed in 3rd of June, my lord. The connected case, my lord.
Okay.
The 3rd June.
The WBC number so and so is ordered to be listed on 3/6/2026. List this case also on 3/6/2026. Let us see. So I have a copy to him.
Yes.
in this petition also, if the common issue is there.
Right.
Public.
Public. For orders, item 16.
In this case, Mr. K. M. Sudhir Senior, he is appearing, my lord. In code number 7, my lord.
Lordship, in the IE, we filed an objection yesterday and it's not on record.
IA for impediment, that is.
And it's not on record, my lord.
And they have filed a objection, my lord. This is on.
Already notification has been issued dissolving the assembly.
Yes.
Is it a dead horse? Or horse is alive? Huh?
No, my lord.
That hasn't already been resolved.
No, quo warranto will be a useless formality. Is it not, Mr. Gautam? There is a notification, right? Kali
They notified today, your lord.
Huh?
Today notified, lord. Out in the gazette, lord.
Ah. So your claim are gone, mister. Have a look at it. Yes, Mr. Mohanto.
My lord,
Will it amount to flogging a dead horse? Sit and
That is up to him, my lord, already.
6 May. We are on 7 May, I think. Assembly is dissolved.
Yes, so my lord, that pair is gone. Either an amendment or.
Just hand it over to him, to Mr. Gautam, to have a view of Mr. Chaudhary.
My lord.
Come back,
Yes.
go and ask.
Yes.
No point. It will occupy the cause list. Now, whether quo can be possible to be issued now,
Right now, you cannot,
to unseat,
my lord.
when he is already unseated by dissolution of the assembly. I don't know, legal.
That is one part, another part also any otherwise made also, my lord.
made
Yes,
not-
that is different. No, no.
Why will do academic
Yes, my lord.
exercise?
That's correct. All right, not today, my lord. Monday.
Let Mr. Karim have some opinion
Yes, my lord. Any other day, my lord.
Huh?
Any other day.
Any other day.
on the, okay, on the request of Mr. Ajad, A.K. Ajad, Plenary Council for the petition is the case on Monday.
Monday? Monday, probably in this case, Advocate General appearing. That's why my lord will not be here.
Lordship, can we fix
When we want?
on the day, Lordship, the week after next week, Lordship?
Okay. Did you?
1805?
No problem.
Just write the names of the council in a piece of paper.
My lord. Deeply.
Right?
Yeah.
Supplementary list, item number 20.
Date to decide?
Item 20.
We have deferred it. Yes, petitioner? Absent.
Lordship.
Any instruction?
Lordship, here in the last,
Artist Soikia. Though there was an order of providing a copy of the calculation, whether several same has not been provided, he cannot, he will provide the same. It will have been submitted by the petition. Have you provided the calculation?
Lordship, we have given the handover to the other side on that. And in the last affidavit filed by respondent number 10, we have sought for some documents to be submitted by the petitioner, Lordship. Yeah.
Okay. Mr. Gogoi appeared. Advocate General. You are for Mr. Dina.
Lordship.
Nothing, nobody has appeared. Will not understand what is the case. There is no representation on behalf of the petition today on call, Mr.
R Sahani on behalf of the Lordship.
R.
Sahani,
Sahani,
Lordship.
Learned Counsel on behalf of Mr. D. Nath, Learned Senior Government Advocate. For the respondent number 7 is present. So, in view of non-representation on behalf of the petition, let the case be listed again. Did you get that? 2 weeks of bishop?
25th May, 2505.